Namaskar viewers, hello and welcome to Sansad TV. I am Teena Jha, you're watching Perspective. Well, more than 6 years after the centre's decision to demonetize the 1,500 denomination notes, the Supreme Court in a 4:1 majority verdict has upheld the move, saying the decision-making process was not flawed merely because the procedure emanated from the government. Ruling that the decision to scrap the high-value currency notes does not suffer from any legal or constitutional flaw, the top court said there was consultation between the Reserve Bank of India and the Union government for a period of 6 months. Besides, the top court also observed that the decision, being the executive's economic policy, cannot be reversed. Justice B.V. Nagaratna, however, dissented from the majority judgment, saying demonetization should have been done through a legislation and not through a gazette notification. So with eminent panelists today, we'll analyze the key points of the Supreme Court's judgment on demonetization in perspective. Pleased to welcome Mr. Desh Ratan Nigam, his advocate, Supreme Court of India. And joining us virtually is Mr. Anand Singh Bhal, he is former Principal Economic Advisor, Government of India, and Mr. A.K. Bhattacharya, Editorial Director, Business Standard. Thank you, gentlemen, for joining us on the program today. Mr. Nigam, allow me to begin the program today with you. Your response to the Supreme Court's judgment on demonetization, and why is this verdict so significant?
Naji, one thing is very important, that this judgment, if it had gone otherwise, would have, destroyed the separation of powers that the Constitution enshrines. Then executive would not have been able to run the country, govern the country in the wake of emerging challenges that we face, the new challenges that are there, or the existing challenges or the old challenges. Say, for example, fake currency was a problem in this country, and our neighboring country was quite a culprit in it. And then you had terror funding, and new laws have been made with respect to terror funding as well, which is one of them is UAPA. Then about black money, tax evasion. These are the issues that only, government of the day can deal with it, not the judiciary. Hence, the Supreme Court clearly said that since it's an economic policy and the settled law is, we will not judicially review on the merits of the case, but we'll look at the process of, this notification of demonetization. Therefore, they went into it and saw the powers given in the RBI Act. Now, there are two ways of demonetization. One, through executive decision, through notification, or through legislation or ordinance. And the dissenting judgment went on to the fact that it should have been done through legislation, having its own interpretation of Section 26(2) of the RBI Act, saying any series is there, the name given is any series out there rather than all series. So the Supreme Court gave an example. Suppose there are 20 series of a particular denomination of a currency. Then it demonetizes 19 of them and leaves one series, because you are saying it can only do any series. That will lead to chaotic situation, because then people will not know whether that remaining one is also fake or not. So it gave a very pertinent example. And the consultative process which is given in Section 26 has been followed for 6 months. The argument was that it was not done. Secondly, it says the doctrine of proportionality. Doctrine of proportionality in simple terms is, suppose somebody goes for hunting. It's a very layman's example. You don't take a cannon to shoot a lion. So what doctrine of proportionality says, the action that executive action or the administrative action that you take should not be so drastic, which should not be more than what is desired for a particular result. So it should be proportional, and the Supreme Court find it to be completely proportional, looking into the objectives it was supposed to achieve. And the third, it says that the period of exchange was also not unreasonable. 52 days were given, and that was also reasonable. So consultative process, reasonable nexus with the objectives was also there. They said we will not go into the objectives, because the government, that's a separate field altogether. How much it has been achieved, not achieved, it's an executive domain. It can be, that you can raise questions in Parliament. That's what I am adding. I mean, if anybody has a problem, whether you can raise a start question in Parliament saying that, please tell me how far the objectives have been achieved of demonetization. that the government is bound to answer if they start
I
question
think the
0 hour.
larger debate is around the objective and the outcome of the entire procedure. But Mr. Bhal, the fact that the judgment today was largely on the technicality of the demonetization process, do you think it sort of affirms the fact that when it comes to economic policies, and especially series of transformative economic policies that the government is undertaking, there should be either no scope or restricted scope for judicial review? Do you read, is that the sense of the judgment today?
Yeah, I totally agree with that. The decision to demonetize 500,000 rupee notes taken in 2016 was within the domain of the government in consultation with the RBI. The monetary policy is a stated objective of Reserve Bank of India, which it executes in consultation with the government of India. So the freedom to execute its monetary policy based on its consultations, based on its expertise, lies totally with the RBI and the government. And the Supreme Court has very rightly decided that the process was all right, and the proportionality was also not out of the picture, and hence it has gone ahead and validated the thing. And so this is a good sign. It augurs well for the process of policy making in the government. I mean, it's it's fairly obvious. It's not rocket science that policy making should fall within the domain of the government, and the judicial sort of intervention engagement should be only on very exceptional circumstances, and if only if the basic structure of the constitution is being changed. Here, nothing like that was happening. It was a monetary policy taken in consultation with the RBI based on the exigencies of the situation, and the government went ahead and did it. And very rightly so, the Supreme Court has not got into whether the objectives were met and this. That is not the domain of the Supreme Court. That lies entirely with the executive of the government. Thank you.
Clearly, Mr. Bhattacharya, the fact that the political debate has revolved around the outcome. So while the government claims that it has managed to achieve the objectives with which the policy was brought about, the opposition's claims have clearly been on the contrary, that it has done more harm than good. And the debate continued. It went to the Supreme Court, and we've seen today the judgment has refrained from getting into the objectives and outcomes, because of which the responses now coming in from the political parties have once again raised questions. But that leaving aside, the fact that, the separation of powers is extremely important, and we keep discussing how it's important for each of the institutions to remain within their domains while performing their duties, their functions as prescribed by the Constitution. Do you think this judgment reaffirms that separation of powers clearly among the judiciary, the executive and the legislature, and that is the biggest takeaway from the Supreme Court's judgment on demonetization?
Well, there can be little doubt that this judgment upholds the legality of the decision that was taken by the RBI under 26(2) of the RBI Act. Now, it is very important to note that the Supreme Court did not go into either the outcome or the objectives and examine them at all. What it did was to establish that whether the Reserve Bank of India and the government of India had the powers to take such a decision under the relevant laws. So I think that's point number one, that Supreme Court's, from the verdict, from the judgment, it is very clear that they are restricting itself to the legality of that demonetization order. That's point number one. Point number two is that the order does not find, except the dissenting order, does not find any problem with the government of India making a move in consultation with the RBI to go ahead with the demonetization decision. In other words, you will remember that on 7th of November, the Finance Ministry had sent a note to RBI asking the board to consider what all necessary steps needed to be taken to tackle the question of our higher circulation of rupees 500 and 1,000 rupee denomination notes. So it is based on that note that the RBI Central Board met on 8th November afternoon and took a decision to recommend the declaration of these notes as invalid. They were no longer legal tender. So technically, demonetization is a media word. It's used, but actually, what happened was these currency notes were declared illegal tenders in that sense.
Right.
That's the point number 2. And point number 3, and that's my final point, is this: that whether the objectives or the outcomes of the demonetization decision were desirable, were achieved, Supreme Court has remained silent, and the jury will probably still remain out on that issue.
Right, and I think that will keep lingering on outside of the court also, Mr. Nigam. But the fact that, the one dissenting judge happens to say that the entire procedure was unlawful, instead a legislation should have been brought about, it should have been discussed in Parliament, because Parliament is where you represent the will of the people. So, how much merit is there in that observation? So, each time there is an economic policy like that, is it possible to discuss it in Parliament, get the will of all the representatives that represent people from across the country, and then bring about such a legislation in a country like ours? How feasible would that be?
See, the fact is, when such kind of demonetization takes place, it has to be full of secrecy. Because if it is declared in advance, people will start, submitting in the bank, or a huge amount of cash transactions will start. All kinds of things will start to defeat the entire purpose of legislation. So it was done in secrecy. So it had to be done under 26(2) rather than the legislation. And secrecy was the important ingredient in this kind of demonetization. Secondly, if you look at the judgment of the dissenting judgment, even the lady judge says the demonetization was well thought of, well intentioned, and well considered. She has mentioned all these words. Only she was on the process. In fact, she touched the merit and said, merit, if we speak on merit, it is a good thing. But process, she says, it had to be followed through parliamentary legislation. I have given you one argument of secrecy. Second is, earlier two demonetizations had taken place through legislation. But government has two routes available. One under the RBI Act, where the RBI Act itself delegates the powers to the central government. The RBI itself does not have an independent function of demonetization. Its role is to advise the government if needed. Consultation is done to the central board, and the decision has to be taken by the central government. It can be negative advice, it can be positive advice. It is only recommendatory in nature, not necessarily binding on the central government. Even if the RBI gives a negative report, don't do demonetization, central government still has the power to have its own independent decision on that, applying its own mind, and can take that decision. So that's very clear. So what the dissenting judgment says, out of the two processes, you should follow one process. That is not the intention of the legislation, nor the separation of the powers between the various organs of the state. It is not even intentional there. If the central government has a power, both under the Constitution and under the RBI Act, to take a decision, they can take a decision. A judgment cannot tell the government, out of the two ways that you have, follow this particular way. So that I think to that point I will disagree to that extent. And the fact remains, I still feel these challenges that had come were politically motivated, and they were couched in legal niceties. And one can easily do it, saying a consultation has not taken place. The fact it is contrary, for 6 months consultation had taken place. So you would see factually incorrect statements were also made before the court.
And of which there was no evidence.
Of which they did not have an evidence. It was mere hearsay, mere speculation. Pleadings cannot be done, if you write in a Supreme Court or any court, pleadings cannot be speculative or based on hearsay. This was completely on the hearsay, not even hearsay. It is lying on oath, let me tell you. To say that no consultative process has taken place and you file an affidavit with it, which is perjury to my opinion.
Okay, Mr. Bhal, the fact that each of us would, and when we were following what's happening in the Supreme Court as far as this case was concerned, the larger point of debate, as I mentioned earlier, was, of course, the outcome. So the government has claimed that a lot of the objectives that it's set to meet out have been met out after the 2016 exercise. What kind of difference do you see in achieving those objectives, which, of course, the opposition is dismissing? They're saying nothing of that sort happened. It did more harm than good in terms of impacting the lower rungs of society, in terms of the unorganized sector that it impacted. But what is the kind of difference that you as an economist have seen the demonetization exercise bringing to our system?
See, the demonetization exercise did lead to a lot of micro and small medium enterprises closing or being hampered, because we all know that they deal with cash in a huge way. It is an obvious fact that the micro, small and medium enterprises before 2016 were dealing with a lot of cash. So it was kind of accepted that once demonetization is implemented, they will be adversely affected. But that was taken into account. And the benefits which the government envisaged through controlling of, that terror money, so black money, and through controlling of corruption, far outweighed, in its opinion, the impact it would make on the micro, small, and medium enterprises. So this was a fact which was taken into consideration. Ultimately, economic policy is a lot about trade-offs. The government of the day, in its wisdom, had decided that the benefits which will accrue to it through implementation of the demonetization process does far outweigh the negative adverse impact it has on certain sections of the economy, and that's how it went on and took the decision. Here, let me also add, even in economic theory, the effect of money supply on prices and output is not on a one-to-one correspondence. It's not truly well defined. Anyone who says that he can control certain levers of monetary policy and it will have this impact on real output and prices is not correct. Even the monetary economists agree that this link between money supply and real output and prices is slightly fuzzy, and it's not a one-to-one correspondence. It's not physics that you say you raise it by 2 and that will increase by 5. That doesn't happen. So when it comes to the final objectives being realized and all, there's a lot of difference in opinion between the political parties, between experts and all. But then that is the richness and strength of economic policy. I mean, economic policy,
Okay.
once a decision is taken, it can be argued both ways. That's one thing about economic policy is slightly fuzzy. The objectives also on the ground are not absolutely clear, that it's not in black and white. You can use your filters and see it in a particular way. But I would like to argue that the government of the day decided in its wisdom that the advantages far outweighed the adverse impact it would have on certain sections of the economy.
Okay, Mr. Bhattacharya, amid the varied opinions on the advantages and disadvantages of the entire procedure, how would you respond to the contention, and which concerns the larger public also, is that it said it would reduce the use of cash, whereas when you look at the actual data, the currency in circulation has increased from 12% of GDP in 2010 to about 14%, which clearly means that usage of cash has not reduced post-demonetization, and this has been one of the major arguments that was done. So in that aspect, how do you look at the contention? What is your opinion?
You're asking me?
Yes, Mr. Bhattacharya.
You hit the nail on the head, because I think among the many objectives that demonetization was supposed to achieve, reduction in the prevalence of cash in the economy was supposed to be tackled. But I think that objective has clearly not been achieved. As you rightly pointed out, cash as a share in GDP has actually gone up. Similarly, the tax to GDP ratio has also remained by and large the same. The MSME sector has been adversely impacted. I think in one area where demonetization has helped is increasing use of digitalization in terms of the payments space. digital payment have certainly got a boost. The results of the demonetization have been actually the actual result has been only on digital payments. On the other front, the outcomes has not been to the desired levels, in my view. Having said that, let me just disagree on one issue with Mr. Nigam's point about secrecy. Secrecy could have been maintained even through an ordinance route. If the government had chosen to go in for an ordinance route and then later on bring the ordinance into legal debate in Parliament, I think that the lady judge was probably referring to that. Remember, bank nationalization or 1978 demonetization happened through the ordinance route, and then they were debated. Now, in an ordinance route, the decision is taken right then, and secrecy can be maintained.
Okay.
And then you give Parliament the right to debate and discuss it. And I think the lady judge was referring to that system, that secrecy can be maintained, and yet a process of law can be followed through a parliamentary system of debate and discussion.
Okay, Mr. Nigam, would you like to respond?
Yeah, sure. Yes. One thing that Bhattacharya Sahab was saying about secrecy. See, in this case also secrecy was maintained, but it had added advantage of RBI consultation, which is an expert body on monetary policy. So that both the advantages the central government had. Secrecy as well as the consultation with the RBI, which is obviously an expert body which deals with currency and monetary policies. So that added advantage they had, and which was already provided under the Act. Now, secondly, when we talk about the objectives it has achieved, today the size of economy has grown. Cash in the market being almost at the same level or more does not mean it is all black money. Although there is a link to it, but it does not mean entirely is a black money. So secondly, if the digital payments have increased humongously, which means the cash transaction, if it had not been there, cash transaction would have been doubled. And at the same time, the economy is very large today. We are aiming for 5 trillion economy, and we are 5th largest economy of the world today. So if the economy is increasing, the cash component is also increasing. But the fact remains, we cannot say that all is black money. It is a fact that the terrorism in India has gone down. There are various factors into it. One of them is that you have cut the source of funding. And secondly, the tax collection has gone very high today, 1.5 lakh crore per month, which is very high, which means to some extent tax evasion has also been controlled. And at the same time, fake money. I remember there was a time there was huge amount of various currency notes which were there, the fake money, and they were there. Today, nobody talks of fake money today in the market. And at the same time, if you look at demonetization was not the only step. Government of India found, SIT on black money. The foreign money, black money was taken care of through, Economic Offenders Fugitive Act. Benami transactions. So number of steps were taken. This was not in isolation. Jan Dhan Aadhaar Mobile Jam platform which was created. So there was a series, and this was one of the factors in between. The government had a very clear vision, and this was one step among many steps that the government had taken.
So whether the merits far outweighed the demerits, or whether, it impacted the common man who had to suffer ultimately, because no matter what, the images of people standing in queues, the impact that it had on unorganized sector, and as Mr. Bhal mentioned, the impact that it had on the MSME sector particularly is something that political parties will continue to bring about. So the outcome is the subject matter of wider debate, which will continue in the times to come as well. But what the Supreme Court has done today is address the technical aspect by saying that the demonetization process by the government was not unlawful. In terms of technicality, leaving alone the outcome and objectives that the court decided not to get into, the judgment has been significant in terms of separation of powers that we keep talking about between the judiciary, the legislature and the executive. So that having been said, time allows me to take up only that much on the program today. I thank all my guests for joining me on the program, sharing your thoughts, your views with us and our viewers. And to you viewers, thank you very much for your time. Before we wind up, I would like to wish all of you a very happy new year. Take care and thank you for your time.